Okay, so I alluded to this already. The statute that requires employers to have written sexual harassment policies and provide annual training says that the Department of Labor, in consultation with the Division of Human Rights, must review their model requirements every 4 years. The law took effect in 2018, so the first review was due in 2022. And that was done, and a new policy was put out earlier this year in 2023. Again, as before, employers are clearly not required to use the model policy, but it's not certain which guidelines exactly you have to follow. Whether the model policy, in other words, constitutes guidelines, and if so, to what extent. So that means there is some uncertainty over the impact of the new model policy. Arguments could range from you basically need to adopt it entirely to be compliant, to as long as you have otherwise met those basic criteria, whatever those might actually be, you may not even need to modify your existing policy as a result of the changed model policy. What we do know is that the model policy itself has a heading that says employers are encouraged to tailor this policy to their individual needs, though as a minimum standard, no section in this policy should be admitted. So that seems to maybe help give us further clarification of which guidelines need to be followed. But really all it says is no section in this policy should be admitted. Does that mean you have to have all of the same section titles? Does that mean everything in the section, therefore everything in the policy must be in your policy? There is not any degree of certainty, nor will the Department of Labor tell us exactly what they mean. So we are left doing the best we can to decide in any given case what to include or not include in your sexual harassment policies. Let's talk about what the changes to the model policy are. I mean, certainly there are plenty of words that were changed here and there throughout the policy, but for these purposes, we're going to assume that your word choice in most cases is not entirely critical. But here are some of the big substantive developments that have happened over the past 4 or 5 years. The new policy advises that sexual harassment need not be severe or pervasive to be illegal, and that intent is irrelevant. When the original model policy came out, the amendment taking out the severe or pervasive standard had not yet been adopted. So that's understandable that they would change the identification of what is sexual harassment because the legal standard has changed. Stating that intent is irrelevant might go too far. The law itself doesn't say that. That is generally understood to more or less be accurate. However, there is some sense in which intent could be relevant. It could factor into what form of discipline gets imposed in a particular circumstance. And if it goes that far, could also factor into the scope of liability that the employer has. But I'm not going to get into all that at this point. Just that is language in the new model policy that would give me some pause. The model policy expands on issues of gender, gender identity, gender expression, as well as sexual orientation. There's pretty interesting language discussing gender as primarily tripartite identification. So that is obviously a different perspective than the historical male versus female separation. There is specific wording in the model policy about cisgender, transgender, non-binary Those terms specifically are used, and there's discussion as to what they mean that is new to the new model policy. There is an entire section, which is why I have that asterisk here, that incorporates bystander intervention methods. Basically, there's a list of things that it suggests bystanders may do when they perceive that sexual harassment is taking place. This includes potentially going up to the person engaging in the behavior and telling them to stop. The reason I put the asterisk is because where the previous language says at a minimum no section in this policy should be admitted, this is the one new component that I would say clearly is a new section. Therefore, if I was going to change my sexual harassment policy, I would probably at least include a section on bystander intervention. The model policy now addresses remote employees more directly in noting that sexual harassment can take place not only in person, but through video conferencing and the like. Obviously, this is driven by the rise in remote employment as a result of the COVID pandemic, which took place just after the policy requirement originally went into effect. There are also attempts to expand the sexual harassment policy to harassment and even discrimination based on other protected characteristics. I'm going to get back to that in a moment in more detail. A couple of other pieces that I think you probably should include in your policy are updates to the time for filing sexual harassment claims with the Division of Human Rights. Historically, you had to file claims with the Division of Human Rights in 1 year. That was amended specifically for sexual harassment claims since the original model policy was put into place. Now employees, starting sometime in 2020, have up to 3 years to file with the Division of Human Rights. So your policy may state that incorrectly at this point if you haven't updated it. To the extent the policy, as we're going to discuss, attempts to lump in other forms of harassment, I note that only sexual harassment allows claims to be filed for up to 3 years with the Division of Human Rights. Other forms of harassment still are subject to the 1 year filing period. So if your policy is going to also reference and include other forms of harassment in addition to sexual harassment, then you probably would want to make that distinction in the relevant section on filing administrative claims. The other note is that what I was just talking about is the time to file with the Division of Human Rights itself. Employees can file in court under the New York State human rights law, and if they go straight to court rather than going to the agency, then they have 3 years regardless of the basis for the claim. There's also a reference to a new hotline that was created because of a statutory amendment a year or so ago. And this hotline, 1-800-HARASS-3, is supposed to put potential claimants in direct contact with an experienced attorney who has a background in handling sexual harassment cases. I haven't heard any direct anecdotal information about how this is working, but I suspect that ultimately what is happening in most cases, or what would happen to the extent this is used, is that if someone calls this number and gets to speak with an attorney, the attorney is going to end up referring the person to filing a complaint with the Division of Human Rights. So I'm not sure how much different that is from filing with the Division of Human Rights in the first place, but they do get to speak to an attorney. The problem is the attorneys aren't paid and are prohibited from taking on the people who call as paying clients, even if the clients would like to enter into that arrangement. So I really don't see why the attorneys are going to have much incentive to do anything other than suggest that they file with the Division of Human Rights where you don't need an attorney to proceed.